Hello and welcome back to the Appellate Practice and Procedure course at Solo Practice University. I'm Todd Smith. Hopefully by now you've gotten to know a little bit about me and you've followed this course through what is now our 5th class. And today we'll be talking about handling an appeal, preparing briefs, part 2. Today we'll be focusing on the appellee's brief and appellant's reply brief. So we'll just proceed on to the slides. Let's get straight into it. This course may be a little shorter than some of the others because we've covered a lot of the same subjects that I would have covered if I were giving this as an independent lecture on these two types of briefs. Really, from a just overall briefing standpoint, you cover a lot of the ground you need to know in preparing an appellant's brief. And so my previous class, class number 4, has a lot of basic information in it that I will not repeat in this lecture, although I have referred to it in the slides. So let's just move on to the introduction slide, and I'll repeat some points from course or class number 4, and notably that being that most appeals are won or lost on the briefing. It is the critical phase of an appeal, aside from perfecting an appeal. And I'll just point out very briefly once again that the purpose of preparing a brief is just to persuade the appellate court to accept your client's position and rule the way that your client wants them to rule. So, but as I said a little bit earlier, the purpose of this lecture today is to focus on the appellee's brief and the appellant's reply brief. And what I'm going to do is, if at all, just gloss over the topics that we've already talked about, and then really focus on the differences between the appellant's brief and the appellee's brief and the appellant's reply brief. So I've covered, again, from some issues from class number 4, just in this bullet point summary in the slide entitled The Basics. So review those, because just in case you haven't seen class number 4, I want you to be sure and keep these things in mind, and I would encourage you to go back and view the video and look at the slides from this course, from class number 4, so that you have the whole thing in context. But these are some of the issues that we talked about in that class, and I'm not going to belabor them again here. So let's move on then to the appellee's brief. As far as issue selection is concerned, you're applying basically the same principles that you apply for the appellant's brief. You don't want to raise any more issues than you need to, because you want to keep the court's attention and you want to maintain credibility with the court. And throwing out 10 issues, 10 grounds, wouldn't necessarily be the way to do that. We talked a lot last time about issue selection and how to frame issues, and I'm not going to repeat that discussion today, but I'll refer you back to that lecture on how to phrase issues as either statements or questions, or as what some call deep issues. And also we talked about avoiding generic issues like, did the trial court err by granting summary judgment? The issue statements in an appellee's brief, much like an appellant's brief, provide you the opportunity to start persuading the judges. And so pick your language and how you phrase those issues carefully. I've got one Texas appellate lawyer colleague who tells me that when he has finished drafting a significant brief, one that probably runs, maybe the draft is 30 or 40 pages, I would say, he might spend the better part of a day sitting around thinking about how best to phrase those issues in the final version. I don't tend to think that long about it. Usually I've kind of got it sorted out in my head, and not everyone has the luxury of taking that much time to sort out how to phrase their briefs. And a lot of this person's caseload is fairly significant. The matters are significant, so maybe it's warranted in those cases. But bottom line is, you might want to think about how you're going to phrase issues as you're proceeding through drafting. And as I have indicated, I believe in times past, a lot of times I will go back and tinker with issues toward the end of the process, and so that I've got a clearer picture in my head of what the appeal looks like overall, and can phrase things in a favorable way to my client's position. Now, in terms of selecting issues to state in the appellee's brief, you want to respond to the issues that the opposition, the appellant, has raised. But again, this is an opportunity for some advocacy. So you want to shape them in your client's favor. And then in addition to dealing with the issues that are raised in the appellant's brief, having restated them or shaped them a little differently to favor the appellee, you're going to want to add issues when that's appropriate. And situations when that might come up is if you need to argue that there has been some error that's been waived, or that whatever error that has been asserted, even if there was an erroneous ruling, say, by the trial judge, was harmless and therefore is not reversible. Or alternatively, another reason you would need to add issues to what the appellant has done is if you have a cross appeal, and we'll get into that a little bit later, some of the details. The next couple of slides I give examples of both simple issue statements and deep issue statements. This is primarily for those of you who did not watch class number 4. These are repeated verbatim from that class. Review them, but again, I would encourage you to go back and view class number 4, where I talk about all of these in more detail. All right, tables and indexes, the slide with that heading on it. These are the same principles apply here as applied in the lecture on appellant's briefs. You want to take this opportunity to, in addition to placing your issues in the tables and so forth, as you see on the next couple of slides, to present things in a way that the Court of Appeals will find appealing and will help put a logical ordering early on in your brief that the court can follow, so that it can sort of roadmap where it is that you're going. So I won't spend a lot of time on those, but it would be appropriate then to move on to the statement of facts slide. And again, many of the same principles apply here as applied in class number 4. You're wanting to tell a story. Tell the story from your client's side, the appellee's side here. You want to do it concisely but completely. And you want to, this is an area where it's probably worth repeating some things I've already talked about. You want to disclose negative facts so that you can own them and take control of them, and not necessarily spin them like you might hear in political discussion, for example, but at least be able to confront them in a way that helps minimize their impact, the negative impact on your client. And then finally, again, it bears repeating as far as factual statements. This is not the place or the time to start arguing your case. I see that fairly often in opposing parties' briefs. This is where you want to tell the story and build up your facts and give the court the facts it needs to decide the case. Not a lot more, because you've got busy judges who don't want to get bogged down in minutia that won't ultimately affect the outcome. So this is sort of an art form, and it really helps to practice writing statements of facts. And what I usually do in that situation is I'll read everything, the record, relevant cases, and so forth, and that will help me when I outline my argument to understand what facts are relevant after I've done some research and really gotten into it. So I'll usually sit down pretty early on after reading the record and doing the basic research and try to draft out a basic statement of facts so that I know how to shape that into the argument. But that's another one of those things that you really need to go back and do a lot of editing of to make sure that you don't have a lot of extraneous facts, or that you're not omitting key facts that are essential to the story. From the appellee's brief perspective, this is your opportunity to correct factual misstatements that your opponent makes in its own statement of facts. This is something that comes up quite frequently, especially with trial lawyers who are still trying to argue their case to the jury in the factual section of their brief. And in our rules in Texas, even they state that if you don't challenge the facts as raised by the appellant, then the Court of Appeals can accept them as true, and that can have a very detrimental impact on your case. So it's necessary, check your rules on that. Of course, that's something I say every lecture, but it may be necessary for you to challenge facts or there be some kind of a waiver issue. So this is the time, if the if your opponent has gotten facts wrong, made outright misstatements, maybe even misrepresentations about what the record says and the facts, you can deal with that effectively in your own facts section a couple of ways. You can maybe make an objection to the statement of facts and point out specifically the ones that are wrong. I've done that over the years. I've done that in table format, bullet points, any number of ways of dealing with that. Maybe that's something we can explore in more detail in the online classroom if you have some questions about that. But then another element to consider when dealing with factual statements in appellees' briefs is, ask yourself whether the appellant has stated the facts in a manner appropriate to the applicable standard of review. For example, if you're dealing with an appeal from a jury trial, and if the case law in your jurisdiction says, like most jurisdictions does or do, that the verdict or the evidence is viewed in the light most favorable to the judgment or to the verdict, and you've got an appellant who's trying the case in the appellate court, stating facts that the jury may or may not have believed, and that's worth pointing out too. I usually will say something to the effect of that the appellant has presented facts in a jury the appellant has presented facts in a light that the jury could have disbelieved, and so therefore it's up to the court to review the facts as stated in the record and make its own evaluation of those. And so, if the appellant is presenting facts in a way that's inconsistent with the standard of review, that's something that the Court of Appeals needs to know about, and so be sure and do that in dealing with your own statement of facts. So, standards of review, the next slide. Again, that is something that almost every appeal comes down to a significant analysis of the standards of review and application of the standards of review to the evidence presented, depending on the issue. So when the appellant has either misstated the standards or has omitted them entirely, oftentimes it is an opportunity for you to remind the appellate court what the standards are, correct whatever misstatements there might have been, and urge the court to apply those standards in your favor, because as the appellee, most often the standards will favor you. Abuse of discretion, if that's the ground, if it's, say, an evidentiary ruling and the appellant is asking the Court of Appeals to reverse a judgment based on a ruling to which the abuse of discretion standard applies, that's an awfully high bar to try and hurdle. And so emphasize that in your appellee's brief, that they have not met the standard for reasons X, Y, Z, or whatever the standard is. Just bottom line, demonstrate, I'm getting a little ahead of myself here, but demonstrate the reasons why the standard has not been met and that reversal from the appellee's perspective is not justified. The summary of the argument slide, I will not spend any time discussing this other than to say that it's the same principles that we've applied in class number 4. You can read these bullet points, and again, I urge you to review that class. So I want to move in generally then to the arguments and authorities. For the most part, when presenting argument in an appellee's brief, you should address the issues that appellant has raised in the order they've raised them. Sometimes you can organize the argument in a way better than they might, and it's very tempting to do that, especially among those of us who are very detail-oriented and want things to flow in a very logical fashion. And there might be circumstances, I wouldn't rule it out, there might be circumstances in which it would be appropriate to provide your own outline, such as if you've got a real winner point that just disposes of the entire case. Maybe you want to address that first. But for the most part, the way to go about this is to present the argument in the order raised, because you are in effect responding to the argument that the appellant has made. And the Court of Appeals, the first thing they're going to see is the other side's brief. And they're going to probably open it up and lay it down. This is what I do pretty often in my own cases. Open it up, lay it down next to your brief, the appellee's brief, and see point by point how things match up. So it makes the court's job easier for the most part if you will follow the order of argument raised in the appellant's brief, again with the types of exceptions that I just mentioned. Scrub that appellant's brief carefully, read the cases that are cited in that brief, and if you discover erroneous reasoning, citing cases for propositions that they don't stand for, discussing cases that really don't apply, or sadly misrepresenting cases. This is the time to point those things out in your argument section under the relevant argument headings. So emphasize the errors that the appellant has made. No brief is perfect, and generally neither side of a case is perfect. So this is one of your opportunities to engage in advocacy, which is what you're getting paid hopefully to do. Distinguish the cases that the other side relies on, in addition to pointing out incorrect citing cases for propositions that they don't stand for. Let's say you've got a case that is dead set seemingly against you. Well, look for the details in that case that will set it apart from your factual scenario, and hopefully provide the appellate court with sufficient reasons for concluding that it does not govern your own case and is not dispositive. So distinguish those cases, and again show that the standards of review have not been satisfied and the reasons why the judgment should be affirmed. Something else you want to do in this section is assert any independent grounds that you might have for affirmance. I'm not sure how other jurisdictions handle this, but that's sort of a term of art where I practice. What it means basically is just raise any other bases that you might have for winning, for getting the result that you want to get, even if the appellant were correct in its argument. And also you're going to want to raise, whatever non-frivolous waiver issues that you have. The best example I can think of is failure to preserve error in, say, the jury charge. We have very technical error preservation requirements for jury charge practice here in Texas, and it's not hard to waive errors. Technically, the courts of appeals are supposed to look at these error preservation when they write their opinions, but they don't always think of it or emphasize it on their own. And in fact, I just had a brief that I filed within the last 2 weeks where there was a jury charge issue raised by the appellant. I was representing the appellee and preparing an appellee's brief, and one of the things I led with was the question of whether error had been preserved. And I concluded, based on the record, that it was not demonstrated that error had been preserved, and so therefore the appellant could not prevail on the jury charge error argument that it was asserting. So raise those kinds of issues, but choose them carefully. If you go around bantering waiver, and you have, the other side raises 3 issues and you raise 6, 3 of which are waiver, after a while, the court kind of stops listening. And so, issues like the jury charge, which are extremely significant in jury trials, that's some potentially fertile ground for raising a waiver issue. Possibly also if there's a complaint about the admission or exclusion of evidence, if there hasn't been a proper objection, that sort of thing. Those are some ways that if those are the key points that the appellant raises on appeal, you provide the appellate court with an easy way of disposing of those issues. And if you've read, and surely you have, enough appellate cases, you see that sometimes those are the ways that the courts prefer to dispose of the issues, is on procedural technicalities rather than to deal with the merits, as unseemly as that may seem sometimes. Another approach to take possibly, and I mentioned this briefly earlier, is to argue that whatever error there was harmless. I mentioned the idea of error in the presentation of evidence. If you've got for example, other evidence that makes the same point, or cumulative evidence to what the appellant is complaining about. That's one example of a situation where you can say, well, yes, even if the trial judge erred in admitting this potentially inflammatory piece of evidence, or whatever hearsay is probably a better example, it doesn't matter because the jury heard the same sort of testimony from this other source over here, and there's no harm in the admission of this evidence erroneously. That the hearsay did not cause, and what we would say where I practice is it did not cause the rendition of an improper judgment. So harmless error is another important point to consider. Probably not as touchy in terms of the frequency with which you raise it as waiver issues, because as a practical matter, every error should be harmful to warrant reversal of a trial court's judgment. And if you can make a legitimate case for harmlessness, it's probably something worth raising. Whereas asserting that your opponent in the trial court waived a bunch of errors, just after a while, I think the courts tend to just turn off and get turned off by those arguments. So as far as the next slide is concerned, I do want to emphasize again that the same basic principles for briefing that we laid out in class number 4 apply here too. Find the best authorities you can find, confront the weaknesses in your own authority. There's some tips here that I won't read back through again, but there's kind of an art to presenting a legal argument in a brief, and I think really to get the clear picture of at least my take on what the best approach is to doing this, I would suggest that you read through what we've got, the bullet points on the slide here, and then also, if you haven't, go back and watch class number 4. Okay, the relief requested. As in class number 4, you want to consider carefully what it is you want the Court of Appeals to do in ruling on this case, even as an appellee. And then you want to ask for it specifically. You don't want to leave the court guessing as to what it is you want it to do. As the appellee, you should generally ask the court to affirm the trial court's judgment, and there are some variations on that. You can ask for it to affirm the judgment in its entirety. You can ask that there be some modification of the judgment, and that can run the gamut from adjusting interest, or conceding. Conceding is tough. I hate to even use that word, but sometimes it's necessary. That if there is an error in the judgment, it doesn't require a complete reversal. The court can modify the judgment and then leave the rest of it intact. So the second bullet point under the last part of the slide, under relief requested, modify the trial court's judgment and affirm as modified. That's where I'm going with that. In other words, if you can't affirm the judgment outright, appellate court, affirm as much of it as you can and only tinker with the things that really need to be changed. And then finally, you can ask, and I would do this strictly in the alternative, you can ask the court, instead of rendering judgment for the appellant, in other words, taking the trial court's judgment away completely and rendering a completely different judgment, you can ask the court to remand for, say, a new trial or some other further proceedings that would be appropriate. And again, I would only argue, and ask for that if what the appellant is seeking would be a complete win for the appellant and a complete loss for you. Otherwise, there are all sorts of other possibilities as far as outcomes, and just think very carefully, I would say, about when the right circumstance would be to actually ask the court, even though you're the appellee, to reverse and remand for additional proceedings. Now, the next slide, I talk a little bit about cross appeals, and this actually is a little different situation. A cross appeal comes up when, even though you're not the primary appellant, you still would like for the appellate court to give you more than what you got at the trial court level. There is a lot of variation among jurisdictions in terms of what the proper way of presenting a cross appeal is. Do you have to actually file a separate notice of appeal to bring a cross appeal? That's one issue. Some jurisdictions would require you to do that, and some wouldn't. So the ones that don't might allow you to raise your cross appellant's points in your appellee's brief. Others require what I call dual briefing tracks. In other words, the other side files a notice of appeal, you file a notice of appeal or a notice of cross appeal, and each proceeds up. Even though it may be under the same cause number, it proceeds as if it were its own standalone appeal, so that you might even have different sets of briefing deadlines depending on whether you're briefing as the appellee or as the cross appellant. My personal opinion on this is that it's silly to do it that way. The federal courts, under the federal rules of appellate procedure, you do have to perfect appeal if you want to obtain a more favorable judgment, but the federal rules deal with it in a way that I think is very efficient, and that is, whoever is the first to perfect appeal is designated as the appellant. The second person, or the next entity to perfect appeal, even though it has its own appeal, is designated as the appellee for purposes of the caption of the case, but the rules set out specific briefing deadlines that factor in the possibility of a cross appeal. So that honestly is the way that I think all jurisdictions should handle it. If you sense some frustration in my voice, it's because Texas currently does not handle it that way. We have this whole idea of these dual track appeals, with the exception of some intermediate appellate courts that have local rules that deal with this situation and actually more or less adopt the federal model. I have handled, we're getting a little bit a feel at this point, but the way that I've handled that issue, and you may be able to do something similar in your jurisdiction if you're dealing with concurrent briefing tracks, is to file a motion in the appellate court asking for leave to raise your issues in your issues as cross appellant in your appellee's brief. I've had some success doing that here in Texas, and probably one of the things I'm going to put on my list of long-term goals as an appellate lawyer is to get the rule changed in Texas, where we don't have to go through this exercise of dual briefing tracks. By getting the courts to grant this motion to raise cross points, or however you want to phrase it, I've been able to eliminate at least 2 briefs from the briefing cycle and concurrently tracked appeals. You file a total of 4 briefs in a case: the appellant's brief, the appellee/cross appellant's brief, the appellant's reply brief, and the cross appellant's reply brief, as opposed to appellant's brief, appellee's brief, appellant's reply brief along 2 separate tracks for a total of 6. It's a lot more technical than I intended to be today, but it's a personal pet peeve of mine, and if you want to talk about that in any more detail, just feel free to contact me through the online classroom. But otherwise, what you want to do as a cross appellant is more or less approach the issues that you would like more favorable relief on as if you were the only appellant in the case. And so, the principles, therefore, discussed in class number 4, for the most part, apply equally to that analysis as they would, as if you were the only appellant. So, okay. With that, we'll segue into a discussion of the appellant's reply brief. And after the slide entitled Appellant's Reply Brief, the next slide is captioned, "Should you file a reply brief?" And that's a good question to ask, because they're not necessary in every case. It is very difficult to let someone else have the last word when you might, by rule or by local custom, have an ability to file a reply brief. I've heard stories about replies and surreplies being filed, almost endlessly until a case is decided. That really isn't the way that appellate practice is supposed to go. Rules your jurisdiction may track more or less the federal model, which is appellant's brief, appellee's brief, reply brief, if any. And if you are the appellant, you're going to want to take a close look at whether a reply brief is even necessary. That said, I almost always file one because I can always find something in the other side's argument as appellee, or I can find something in my argument that needs further fleshing out. And so that's what we're getting into when I ask the question, should you file one? If all you're going to do, if the other side does a relatively poor job, if the appellant does a relatively poor job briefing, and really doesn't take on your arguments directly very well, or the arguments that they do make are fairly well covered within what you've argued as the appellant, and all you're going to do is just repeat things that you've already said, don't waste the court's time. Save your time, save the paper, save your client some money, but talk through it with your client, because your clients generally are going to be hesitant to let the other side get the last word. I will say that sometimes, as counterintuitive as this can be, sometimes it's the right thing to do, and I think the courts actually appreciate it. But that said, if there are issues that are raised, or questions that aren't answered that need answering as a result of a careful review of the appellee's brief, then by all means, subject to whatever your rules say, prepare and file a reply brief. So what does a reply brief look like, or what approach should it take if and when it's filed? Generally, there aren't the kinds of categories laid out in the rules for reply briefs that designate the specific sections that would be required. It's pretty loose. Most of the time, you'll have just follow the conventions that you followed in preparing the appellant's brief. You'll have a table of contents. You'll have an index of authorities. You'll have an argument section. You'll have a request for relief, and all those major sections. But beyond that, typically, rules are very fluid or undefined as to what should go in reply briefs. I'll tell you the approach that I take most of the time when I file a reply brief is I have sort of an introductory section, or what I sometimes call a preliminary statement, which really is just a little variation on a summary of the argument. I usually will try to really hit just as finely as I can the overall point I'm making in the reply brief, and do it in that section. And usually I hardly ever exceed half a page in a reply brief in drafting that section. It is sort of just a little segue into the main body of the reply brief, which of course, my take on any brief is that if it's possible to make it relatively short and try to make the case seem simple, that's what you should do. So, it's sort of a zing right in and get to the point that you're going to make, and then in the argument section, make the point and flesh it out in more detail. Something else to do in considering the arguments you actually make is to take a look at what has been presented in both the prior briefs, and ask yourself what questions the court might be asking when it reviews these briefs. If there's some discussion of case A, and the other side talks about case A, the appellee talks about case A, and it turns out they represent it to be completely different, then loop back and explain how their version of it is wrong. Address problems that the appellee's brief creates for you, and those will be apparent as you've gone through the time by this point and trouble of preparing an appellant's brief, and you've read the brief that the appellee has prepared and filed. you know at this stage of the case what the weaknesses are in your position, and you know you should be able to determine fairly easily what the weaknesses are in the opposition's point of view. And so, address the problem areas raised in the appellee's brief, but also point out the problems with the appellee's brief. And that may require also, in addition to dealing with facts, it might require further explanation of the case law, statutes, underlying policies, and that sort of thing. But the bottom line, what you want to do is you want to make it brief. By now, the courts have read, potentially, depending on your page limits in your jurisdiction, heaven forbid, 100 pages of briefing. There really isn't a need to file another 25-page brief, except for the most complex cases in which there's disagreement on multiple issues, and you really just have no choice. And those do come up, but they don't come up all that often. For the most part, what you can do is you can get in, say what you need to say, and get out, and the court will appreciate you for it, for being as brief as you can be in your reply. So that about wraps up the substantive content for today. And as I've indicated on the slides here, I do plan on posting more briefs on my JD Super profile. I'll have eventually, and hopefully within the next week or two, I will have a pretty good sampling of appellants briefs that I've done, appellees briefs that I've done, and appellants reply briefs that I've done in state courts in Texas, and maybe one or two Fifth Circuit cases or other federal courts that I've got in my form files. So feel free to review those. And hey, I have to admit, I'm human. I don't always follow my own rules. So you probably will see exceptions to my own rules in those briefs. And actually, part of one benefit to me of preparing this course and teaching this course has been to force me to think about how I do things. And I see in some of my own past work that I have not done things that I suggest that you all do. And don't think of me as a hypocrite. This is an ongoing learning process. As a lawyer, you will always learn new things, and I'm no exception to that rule. So, but my recommendations are, as I've explained them, as far as briefing in the last couple of sessions. And if you have questions, again, as always, feel free to call me during my office hours. If you want to call me on something I did in one of my briefs, I'll try to explain it to you as best I can. If not by telephone, then let's get together in the official study group on the SPU webpage, or we also have the Appellate Discussion Lounge, as I've talked about several times before. So for next time, class number 6, we're going to talk about oral argument. I'll spend probably the majority of the course of that class talking about oral argument, and then the next phase of an appeal, which is usually the point at which the appellate court issues a decision, and how to go about handling that and discussing it with your client and that sort of thing. So till then, I look forward to seeing you next time at Solo Practice University.